rise. Court of Appeals, Division 1. Now it's
Morning, please be seated. We're here today for oral argument in the matter of Tim Tarter et al. Versus Douglas Bendt et al., our case number 1CA-CV19-0703. We have conferenced the case already this morning. We've reviewed the record in your briefs, so we're pretty familiar with the facts and arguments, and keep that in mind when you decide how you want to allocate your time. Appellant, you are entitled to reserve time for your rebuttal if you wish, but you have to keep track of that yourself. We don't keep track of it for you. I believe you'll be able to see the clocks in front of you that will keep track of your time. And what else was I going to say? I forgot something else. Oh, stay at your counsel table. If you want to remove your mask, you're allowed to, but you don't have to. And also, we are going to record this. We may be live streaming it. I don't know. I don't know if anybody's watching, but if they are, hello. But we will record it and post it to YouTube later, so please make sure that you announce who you are and who you represent when you begin so that people later watching it can kind of keep track of the parties. Is there anything I've forgotten? No? All right. I think with that, we can begin.
Thank you, Judge. Do you prefer I sit or stand?
Sit, I think, since the mic's down there. You bring it just a little closer to you so we can hear you well.
Can you hear me? Okay. Thank you. I'm Lori Vopel, counsel for the appellants Douglas and Sonia Bendt, and with me at counsel table is my colleague Petra Emerson. In this case, a jury awarded $1.5 million to a limited public purpose figure who failed to prove actual malice or actual damages or injury, resulting primarily from a homeowner's statements in a newsletter sent to a handful of residents in her HOA regarding matters of community interest and purpose. This verdict instead resulted from passion and prejudice that was created by hordes of evidence that primarily involved statements made by Ms. Bendt in private emails, communications with one of her best friends, Suzanne Brooks, and with primarily one former...
Isn't that how they proved malice, though? Those emails showed her state of mind and intent in going after Mr. Tarter?
With all due respect, Your Honor, what malice has to do with under New York Times versus Sullivan is the truth or falsity of the statement and whether the person knew that the statement was true or false. And that the specific defamatory statements that were alleged in the complaint related to specific topics that many of which were unrelated to those emails.
And her intent wouldn't go to show whether she, or is irrelevant, is that what you're arguing? To show whether she acted with reckless disregard for the truth? In other words, she had such a vendetta against Mr. Tarter that she was willing to overlook obvious shortcomings in her statements?
Your Honor, what I think happened is that there was this avalanche of evidence, some of which could have gone to that, some of which did not, but none of which was sorted through under the rules of evidence by the judge here.
And did your client raise objections at trial to the specific pieces of evidence?
Your Honor, it was pretty clear from the ruling on the motion for reconsideration that, and as well as counsel's position, was that any objection that could have been raised at the time...
How do you say that it's pretty clear? Because I don't read the record as clear at all. And in fact, the judge later sustained a Rule 403 objection to one of those pieces.
Your Honor, I believe that because of this is a defamation case and because so much of that evidence, we're talking here about evidence that counsel for plaintiff was trying to use and did argue as additional defamatory statements that were not specifically alleged in the complaint. And so it's our position, and it was trial counsel's position, that that evidence needed to be examined fairly closely before trial.
Well, then why did you object to it when it came in? I mean, on a specific basis. If you believed it needed to be examined closely, then you would be, oh, here's a statement. Objection, Your Honor, that statement violates the rule, or it's a 403 problem. But you didn't do that, did you?
Your Honor,
It calls for a yes or no.
no, sometimes she did. That's correct. And I do think, with all due respect, that there was some confusion on her part.
I assume that you're speaking to us with respect, so you don't have to keep saying with all due respect.
If I may, even if you take all of that, take it into account and say, well, you know, she should have objected and she did not object.
We have a waiver rule. And she didn't object to the specific evidence as it came in. And it clearly, her motion in limine didn't identify for the court what it was that she was objecting to.
Your Honor, they were limited to 2 pages. And so our argument is that, and what I believe should have happened is that the court, she was trying to determine, is the judge going to stick with the law of the case ruling? Or is she going to reconsider that and look at this evidence and weigh it under these rules?
But the fact that they then objected specifically on 403 grounds to one of the emails that was contained within that improper original motion in limine completely belies that, in my opinion.
Your Honor,
They did say the judge was not going to stick to the law of the case because when they had a specific one to raise an objection to, they did.
they did, Your Honor. And if I can, even assuming, if I can just shift here just for a moment to say that even if she waived those objections, that the evidence, all of that evidence, was still insufficient to demonstrate that the specifically alleged defamatory statements were either false and or made with knowledge of their falsity. And we laid that out pretty specifically. The alleged statements were, number one, they were a number of statements made in the newsletter.
Isn't that a jury question, though?
Your Honor, this court has an independent duty in a defamation case, especially involving a public figure, and here is a limited purpose public figure, and matters of public concern, to not defer to the jury, but to go back and independently review the evidence to determine if it is sufficient under a heightened de novo appellate review standard to determine whether, in fact, actual malice was met by clear and convincing evidence. And that is what the court under Dombey and Chavez must do.
That your client says, well, I was told X, and that's why I put it in my newsletter. And then those people who she claims told her X testified, I never told her that. How are we supposed to, as a court of first appeal, resolve that conflict in the evidence, other than saying the jury heard conflicting evidence and resolved it?
Your Honor, as to, and I can go through each of them we did in our briefs with respect to both
Did a nice job.
the budget deficit, that there was evidence, that evidence was in the record, and it was admitted to. There was a $40,000 deficit in June. That was accurate. Secondly, in September, when she republished that, she was prohibited from contacting the property manager. The information was not widely available, and there were no public meetings. The very minute that the treasurer...
Doesn't that constitute reckless disregard?
No, Your Honor, because...
To
Pull the September newsletter for me. First of all, the republication in the September newsletter, I would ask you to look at. It's a teeny tiny little statement, which she immediately retracted. It's not reckless disregard.
Where is it in the record that she retracted that?
Your Honor, it is in her testimony, and...
Right, but I mean, other than her claim that she retracted it, what is the evidence to support that?
It was also in, Treasurer Castleman also testified to that effect, that she, in fact, withdrew that. And if you can find that site for me, I'd appreciate it. But he specifically testified to that effect, that she put it out there that it was the wrong information, and then praised the board.
I don't want to, you obviously get to use your time how you want, but I think we would like to hear some of the argument on the insurance issue. And if you want to keep talking about this, you can, but just something that we all found very intriguing.
On the insurance issue, as you know, the testimony was from Mr. Nickel that this was a $2 million defamation policy. The judge allowed that in, and regardless of whether trial counsel opened the door to that, The important piece is that the court did not include any language as requested that the jury could not consider that the insurance policy in assessing damages. And in fact, it was counsel for the Tarter's position that the jury could in fact consider it
Did he
on
make any
damages.
argument like that during closing argument?
He requested $2 million in punitive damages, Your Honor.
I'm sorry. Did he make any argument in closing argument that they should consider insurance for purposes of damage?
No, he did not, Your Honor, but I don't think that that was where he's requesting $2 million in punitive damages. With all respect, I think that's a leap that they could take pretty fairly. As far as...
Why is damages not something the jury could consider? Why is not insurance something the jury could consider in assessing damages?
Your Honor, a jury cannot consider damages, and if I can find my case on that, if you could give me just a moment.
And I'll tell you where I'm going with this.
Under Ritchie versus Krasner is one of the cases, essentially, and under the Raji. I mean, that's the whole purpose of why insurance evidence is generally inadmissible and considered prejudicial, is because you don't want...
That's what the Raji says?
That's correct.
And I was surprised, though, when I compared the Raji to Rule 411, which does not mention damages as something that the jury can't consider. So what is the authority other than the Arizona or Virginia Law Review article, which I generally like things that come out of Virginia since I went to law school there. But other than that, what is the authority?
I believe, Your Honor, that... Hang on just a moment. I'll find that for you for rebuttal if I can.
Yeah, my gut was like, oh yeah, they can't consider that.
Correct.
And when I actually tried to find something to support
under
that,
Ritchie versus Krasner, I mean, if you understand and look at the cases, the whole purpose of that rule is so that you can't say, I'm going to award damages because that person has insurance. And that's what happened here.
That's not what 411 says. 411 says you can't do it for liability.
You can't.
Wouldn't we be, you're asking us to add on to 411?
Your Honor, it's for both purposes, and it has traditionally been treated as that for both purposes.
I'm one of those who thinks that I have to look to the text of a statute or rule first. So where's your purpose argument coming from?
There's a Ventura case, I believe. Oh, okay. It is cited in our, I believe, in our reply brief or our opening brief. Let me find it real quickly. Oh, you have it. And I'll find that for you, Your Honor. I'd like to reserve a few minutes for page 17 of our, looks like our opening
You've got
brief.
846 left right now.
Oh, okay.
So.
Oh,
I
good.
would like to get into the instances in which evidence of insurance can come in, because the rule does indicate that there are times when it can come in. In this particular case, the Superior Court found that your client opened the door to that testimony when asking the witness the reasons why that witness did not sue for defamation. So why is this not one of the instances in which insurance information would be admissible?
Your Honor, asking someone why they didn't proceed, or asking somebody if they did sue or did not sue, and them saying that really calls for a yes or no answer. The judge did find that...
Wasn't there a question of why? Wasn't there a question of why?
Why does it call for a yes or no answer? Why didn't you sue? Yes. That doesn't answer.
No, I believe that the first question, Your Honor, was whether she basically said, you did not sue, did you?
Didn't she? It was my recollection, and I may be wrong, that the question was asked why.
Your Honor, and it's our position that even if she did open the door, that the jury should not have been allowed to consider it for purposes of damages, and there should have been an appropriate limiting instruction and final jury instruction.
So are you conceding that at least the coming in of that testimony was not improper, allowing that testimony in was not improper?
I can understand why she found that it had been waived based on the pretrial discussions. it's our position that that did not necessarily call for discussion about the insurance policy, but that
Even if
said,
that was the witness's reason for not suing?
that would be the opposite, with all due respect, Your Honor. If you have an insurance policy, it seems that you would sue. And that's
Well-
one of our arguments, is that it's the opposite. It should have the opposite effect.
Right, but it's for this particular witness.
Counsel, I thought, and excuse me for interrupting.
No, go
Judge
ahead.
Cruz, but I thought that it was, I knew she had an insurance policy, and so they would defend it, and it would drain me dry, I'm paraphrasing that.
Fighting for years or something.
Fighting for years or something to that effect. Why
It-
isn't that relevant to explain why he didn't file the lawsuit?
That flip side, I guess, potentially is, Judge. The other side is there's a deep pocket there, so why not sue?
But, right, but
So-
but now we're just talking about the motivation of the witness.
Correct. And again, basically what and Ventura versus Kyle is the case that we cited for it, which was 825 F3rd 876, Judge. That was one piece. What our argument is that collectively, that the $2 million defamation policy, the additional evidence that came in without being subjected in the first instance pre-trial to Rule 401, 403, and 404, the lack of evidence regarding actual malice, in other words, that she made the specifically alleged statements that were alleged as defamatory from the newsletter, that lack of evidence that she made those, that they were either false or that she made them with knowledge of the falsity, the amount of evidence that came in regarding things that Ms. Bendt had said in private emails that were indisputably taken without her permission from her email account about other people, about events before Mr. Tarter's tenure, about events after Mr. Tarter's tenure, and about a host of other issues, ended up coloring this jury's view and creating a verdict that was excessive, clearly excessive, for a woman who is a homeowner in an HOA making statements that are critical about a limited public purpose figure, Mr. Tarter, not in his capacity out there practicing law, in his capacity as president of that HOA, about matters of public concern, including the deficit, including board members making decisions unilaterally and then the board ratifying them afterwards, primarily in closed executive sessions, and where basically the audience here are other interested and concerned members of this homeowners association, about 20-some people who got this newsletter.
Now, counsel, you say that it's not about him out there practicing law, but she did reach into that, or at least insinuated that she might threaten against his license, that she might file a complaint and seek to have an investigation opened by the AG, which goes beyond.
First of all, Your Honor, again, Mr. Tarter wouldn't even have known about that had they not made arrangements to take surreptitiously her emails. Those were made in emails to two other people that were considered private.
To other community members?
To Mo Stein, who she was basically asking, he had been the longtime former president, and she was saying, isn't this a violation? I think this is a violation. He was echoing back to her, yes. These are ethical. This is improper. This is illegal under both the CC&Rs and under the open meeting laws. So she's not out there respectfully on the website, on websites, on the internet, slamming his reputation, nor did she follow through with those suggestions to turn him into the state bar. He wouldn't have even have known about them, Judge, and no one in the community knew about them except for Mr. Stein until until Mr. McCall took those off of her personal off of her personal email account after she used her laptop in the clubhouse, forwarded them to Mr. Nickel, who then forwarded them to Mr. Tarter, and then Mr. Tarter gave Mr. Nickel the floor at the next meeting, and he read them out loud.
So is
That's
your
how they were
is your
published beyond
position
Mr. Stein.
Defamation is not actionable unless you find out about it?
No, Your Honor.
Okay.
I'm
You only
saying
have a
that
minute 40 left. So I don't know
I'm
if you
saying
wanna
it's not
reserve
worth
your time.
$1.5 million when these are matters of public importance and concern regarding a limited public purpose figure, and I will reserve the rest of my time.
Thank you.
Thank you.
Counsel?
Thank you, Your Honor. Again, Bill Richards on behalf of...
You probably should stay seated unless you just can't do the argument
Your
sitting
Honor,
down.
I was having a problem seeing Judge Cruz over the bench. That's why I stood up. But if you'd like me to sit, I'm happy to sit.
I'll leave it to
I
Judge
think,
Cruz and
does
you.
it help if I move over? Hold on.
That would help some.
Okay.
Yeah, and I don't,
There you go.
that's fine. And if you'd like me to continue wearing the mask,
No,
I'm
that's
fine with that too.
It's just the mic, if you stand up, it would be a little distant from you.
Let me get it close
Okay.
as well. Okay, thank you, Your Honor. I think, may it please the court, I'd like to probably jump right into the insurance issues because it sounds like that may be the issues. that's
I
kind
think
of
you
the
should
hot
get to
button
that,
here.
but I want to talk to you a little bit about whether these were actually defamatory statements.
Yes.
So give me your best shot for how these are defamatory as opposed to just kind of statements we would expect when people speak of matters of public concern.
Your Honor, let me start with this. First of all, that the Arizona law is very clear that in the world of defamation, one doesn't look at a single word, a single sentence, a single statement.
Let me interrupt you again,
Sure.
just because, and this has become a pet peeve of mine. When people say things are clear, I don't believe them.
Okay.
It usually
So-
means they're not.
Yeah. So
Yeah.
if you want to tell me a specific statement of a case or a statement of law, go ahead. But just when you say generally things are clear, I go,
Okay.
they
Fair.
probably aren't then.
Fair, Your Honor. And, Your Honor, I could get from our briefs a specific citation, but there is Arizona law we cited to you, which indicates that the exercise of a trier of fact in a defamation case is to consider the full context of the statements. That includes not just the statements themselves, it includes other statements that were made in the same, perhaps in the same document, it includes other statements that were made in the same relationship, it includes other statements that were made to other people even. It's a very large, holistic review of the context of those statements to determine what message they conveyed. The argument we made to the jury, Your Honor, that I'll make to you today, is that the multiple messages, and Your Honor, we made it clear, and in our brief, we've showed you multiple pages that the defamatory statements here came out of a multitude of communications. It wasn't just one newsletter. There were at least 3 separate newsletters, all very lengthy, that the jury was given. They were given a multitude of emails in which many of these same statements were repeated or variations of them were given to other members in the community. And, Your Honor, here's what they boiled down to. And here's what we argued to the jury and what the jury found, obviously, is that, oh, I shouldn't say obviously, Judge, I believe that they found, based upon the verdict, that what Mrs. Bendt was conveying were several things. Number one, she repeatedly talked about Mr. Tarter and his board. And by the way, Your Honor, because, again, under the Arizona law we cited, because Mr. Tarter is part of a small group.
Right. And when you defame a group,
Defame one,
any
you defame them
individual
all.
member of the group can, yes.
But as you've seen from the record, the vast majority of the allegations were Tim Tarter specific. But they were that, number one, he had led the group to conduct multiple illegal contracts. Not just unwise, not just, they spent too much or they did the wrong thing, but they were illegal. They violated the law.
She clearly criticized the contracts. Where did she say specifically, this is an illegal contract or this contract violated the law?
And Your Honor, if you want to look at those newsletters, I'll ask Ms. Stewart here to provide some specific citations, but I believe we've cited those where we have in the record the citations to those specific allegations. You'll find the evidence where she published those specific types of allegations.
I assume you'd agree with me that saying something is a bad contract or this was a what's not fiscally prudent contract is different than saying something is illegal. Right?
Absolutely, absolutely.
And the first would not be actionable and the second would. Saying something is a bad idea is not actionable as a matter of defamation, but saying something is illegal is actionable.
Your Honor, perhaps There may be some context in which saying something's a bad contract could be defamatory. I can't think of it right now, so I would concede that.
Something that's illegal may not necessarily be defamatory. It could just be a poor choice of words.
Well, Your Honor, I think, and I apologize, I didn't mean to cut you off. In the context of, you're talking about, number one, Mrs. Bendt knew that Mr. Tarter was an attorney. That was special. That was important to her. That was important to him because of his reputation, his need, as we all have the same need, to have a sterling reputation for ethics, integrity, honesty, especially in the work that he does, which is generally representing high net worth individuals in tax cases, specialized tax cases. It's very important to him, and she knew that. And that's what she was attacking. She was sending the message that here's a guy that regularly breaks the law. Then he does it in multiple secret meetings so that he can hide that from his neighbors, his community, that they illegally spent money of the community on these different contracts.
Again, because I've looked through a lot of this, and I'm not going to say that I've read every second of trial transcript and scoured every email, but I've read a lot of them. And point me to a couple, like where it said he violated the law or he acted illegally, and that's kind of what I'd like to see.
You got to tell me what exhibit this one was, though. Is this 86? This is 103? Okay. 107, Your Honor, Exhibit 107, the July 2014 Fairway Times.
I'm sorry, Exhibit 107?
Yes.
Yes.
At the second...
Is that the July 2014 one?
It is, Your Honor.
I actually have that one right here in front of me.
Okay. On the second page, Your Honor, there are allegations of violations of the CCNRs. There are specific statements on the second page about the ratification of various
Let's
issues.
stop. Where does it say that he violated the CCNRs?
I apologize, Your Honor. Second page.
Uh-huh.
It's base number 019304.
Right.
And it's subparagraph numbered 4 at the bottom of the page.
That's what you're relying on.
Well, Your Honor, this is...
Because I'm going to read it in here. Did some board members violate the CCNRs? Question mark. That is not an allegation or provable statement of fact. That is a question. So how is that defamatory?
Your Honor, again, it's when you put, this is one example, one of many, many examples where these same type of allegations, violations of the CCNRs, violation of the Arizona HOA laws, illegally ratifying contracts, those were made over and over and over again. And when
Or was the question asked over and over and over again? That's kind of where I'm getting hung up, is because a lot of these statements seem to be questions, and I don't know that we want to say that people can't question whether you're violating the law.
Counsel, I have a statement here, and let's see if we can place it. It says, Mr. Tarter has made a motion to ratify wrongful and inappropriate past behavior by some board members who violated CCNRs and cost our HOA money. There have been many problems, including the board not following the proper process and violating CCNRs, and he has failed to involve the community owners by not sending notices of open HOA meetings to all owners in advance. Those are some of the statements made by her, and those were made, did those come from the newsletter?
I believe those are, yes, in the newsletters.
So those would be affirmative statements of violations of his participation in ratifying violations of CCNRs and also of failure to provide notice of HOA meetings
Yes.
and not following proper process.
And spending of money in violation of the CCNRs
Correct.
and the law as well. Yes, Your Honor.
Before you move on, I have a quick question, and it's something I'm struggling with, that in this area. Do you agree with appellant's counsel that our review here is de novo? And if it's de novo, how does an appellate court review de novo a defamation action when you're talking about inferences to be drawn from particular statements?
My answer to that, Your Honor, is that the Dombey decision in Arizona, which is the principal decision I think the council's citing to there, it doesn't say that your review overall of everything in a defamation case is de novo. What it says is when it comes to the actual malice standard, the determination of whether or not the speaker was acting with knowledge of the falsity or reckless disregard for it, as to that, once you have a jury trial, what the case says is it becomes a mixed question of fact and law. Unlike a traditional jury trial where that decision would be strictly a question of law for which the jury gets deference, here it's a mixed question. Here's the way I interpret it, Your Honor. The question of fact is, did Mrs. Bendt act with actual malice? Did she know or recklessly disregard the truth or falsity? The question for the court that the court does its higher level review on, and is a question of law, is as to the evidence that was out there from which the jury drew that conclusion. You know, the jury gets discretion for that conclusion, but as to that evidence, does it rise to the level of clear and convincing evidence? That is the court's role in that kind of special world, the special protections provided by the First Amendment. So, Your Honor, I think the ultimate answer...
what Dombey said was, we must exercise independent judgment and determine whether the record establishes actual malice with convincing clarity. So.
Yes, and Your Honor, it does. I believe Dombey also talks about the mixed question of fact and law.
It does.
I'm also hearkening back to some of the other decisions from which Dombey draws, which obviously are federal authority because of the First Amendment implications, and decisions after that as well. But that's my interpretation of Dombey. So it does put you in a special position to determine whether or not all of this evidence that has been cited was given to the jury could meet the clear and convincing standard for that, but it does...
Are we giving some type of deference on, are we viewing it favorably in light of what the jury found? Because it seems to me that if you're talking about convincing clarity, that you have to determine that the easy case is, you know, the plaintiff called the defendant called the plaintiff a rapist, and there was no rape.
Right.
Okay, great. It's clear-cut defamation. But, I mean, your brief goes on and on about the nuance of these statements. And does that rise to a level of convincing clarity?
Your Honor, this is the way that I think it's appropriately viewed under that standard. If you look at the evidence, all of the evidence that's out there, and you don't reinterpret the evidence for the jury made their decision, they found actual malice, and they're entitled to deference for that. But you look at that and say, well, does that evidence look like a 51-49 decision, right? Which is not clear and convincing. That's just preponderance, basic preponderance of the evidence. Or could a reasonable juror say, no, I see more there than 51-49. I see the evidence, for example, of Mrs. Bendt saying, I was relying on Mr. Stein, I was relying on Mr. Castleman. In reality, Mr. Castleman and Mr. Stein repeatedly testified, no, I wasn't the source of that. No, I did not tell her that. No, I did not say anything about Mr. Tarter being asked to resign. I did not say anything about secret meetings. I did not tell her that we had overspent into a crisis situation. They could look at all that and say, well, that's more than 51-49. On actual malice, on whether she knew what she was saying was false. And respectfully, Judge, I shouldn't say respectfully, but in this case, I don't want to be disrespectful. In this case, Your Honor, there's more than enough evidence to meet that standard. It goes way beyond the 51-49. And so I do believe that the jury, you're still looking at it from the standpoint of a reasonable juror. You don't divorce yourself from that, right? We're always looking at it from the standard, could a reasonable juror make this decision? But what you're considering is, could they make the decision that there's more than a mere preponderance of evidence on the actual malice, that there's more than that, significantly or substantially more than that, or the courts don't clearly define what that exact weighting is. In this case, though, Your Honor, I think it's important, and I realize when you have that sort of de novo review, you don't rely on what the trial court said, you don't give deference to it for that particular piece. I think it's instructive, though, to look at what Judge Mahoney did. In her September 25th, 2019 ruling, she specifically took on these very issues because they were raised in a post-trial motion, right? And she specifically walked through and said, I've I saw everything, I heard everything, I saw the multitude of exhibits, heard all the testimony, and I find that not only have they met the standard, she acknowledged the actual malice standard, she acknowledged the clear and convincing standard had to be met, and she said, I find that the evidence is abundant and compelling for that. Now, Your Honor, that's one person's opinion, but I respectfully submit that Judge Mahoney, as an experienced, well-respected jurist who sat through all of this, certainly is a good proxy for a reasonable juror. And Judge Mahoney found, I think it's instructive, that she found that it was abundant and compelling. It went way beyond the preponderance standard. So I hope that's answered your question, Judge.
Let's turn to the insurance issue that you wanted to start with and I distracted you from.
Yes, and Your Honor, if I could, and I apologize.
It's your
that I
time. You use it how you want. I was just
well, Exhibit 130, just answering your earlier questions also about some of the other allegations about wrongful conduct, wrongful ratifications, violation of the CC&Rs. If you look at the first page of Exhibit 130, the September 2014 Fairway Times newsletter from Mrs. Bendt, the very first page, she talks about the CC&Rs. You know, again, this is her style, is to put it in a question. She says, why were the CC&Rs not enforced? Well, it's got a question mark on the end of it, but it's a statement. It's an affirmative statement saying that they were not enforced.
Well, and that, to me, is a different question than did they violate the CC&Rs.
Right.
When you say why weren't they enforced, that explicitly implies that they were not enforced.
And Your Honor, that's consistent, though, with the style here that the jury saw, and it was the jury's discretion to determine what that meant, what was intended by it. On the second page, there's a statement in there, it's a highlights of what the current board did wrong. Number 1, violated the CC&Rs. Number 2, used HOA funds without proper prior approval. 4, cut Fairway Lodge trees without the required approval. That's where she had told people that they illegally cut down these trees, but she also admitted in an email to a friend before she ever said that Tim Tarter wasn't involved in that. In fact, he was furious about it. But then she alleges that he's involved in all of that. Those are just some more examples, Your Honor, of those type of allegations. And obviously, we'd be happy to provide more, but I want to talk about the insurance issue for just a moment. I don't know how much time I have.
You have
Not a lot.
346.
Two issues, Your Honor, there. Number 1, obviously, is the admission issue. Excuse me. We talked about, or you talked about, opening the door to that. The door started being opened in opening statement because Mrs. Bendt's attorney stood up and promised the jury that they were going to try reasonableness. They were going to try whether Mr. Tarter was reasonable in being upset, being offended, being concerned about all of these things that Mrs. Bendt was accusing him of as an attorney. And that they were going to find that he wasn't. That she basically was saying, you're going to find he's thin-skinned, right? That other people weren't concerned about this. And then she asked the question, and Your Honor, I think it's really important to note the procedural aspect of this. They filed a motion in limine on the insurance issue. We argued to the judge that there could be reasons why insurance becomes relevant, and we gave the judge this sort of example is, this may become relevant. Judge Mahoney said, I'm going to reserve my decision. She made it very clear to me, however, that it's not coming in unless something very different happens at trial that makes this really relevant. I didn't ask Mr. Nickel a single question about that. On cross-examination, however, after he testified about his own experience with Mrs. Bendt, both during Mr. Tarter's time on the board and after, he was asked, the very second question was, and you didn't sue, and despite all of this, you didn't sue Mrs. Bendt. And the clear implication went right back to that opening statement that, you know, Mr. Tarter is just whining about something that...
Counsel, was the witness asked specifically why?
No, Your Honor, he was not. But immediately, I recognized, well, I know why he didn't sue. And now I'm entitled to rebut that implication that he didn't sue because it's not a big deal, because there really wasn't anything to worry about, because it's not a real it's not really defamatory. So I approached the judge. I didn't ask him the question. I approached the judge and said, I think we may have that unique circumstance here, Judge, where it's relevant. We argued it. It was a lengthy argument. It was carefully considered. And Judge Mahoney, I think we quoted her statements from that to you, where she said to counsel, she said, I couldn't believe you asked the question because you were trying to set up this implication, and the next obvious question is, why didn't you sue? And she said to counsel, he could have answered it in response to your question. It's relevant. It came in for that purpose, Judge, and I don't think there's
Let's
any
turn
abuse
to
of
damages,
discretion.
and I'll tip my
Sure.
hand and say, I think you're right, the door is open, but what about damages?
Okay. Which part of damages, Your Honor, if you could
Why
specify?
wasn't the jury instructed not to consider
Oh,
it?
I apologize. So the instruction on that.
Yeah.
Your Honor, I think that there's a couple key points there. Number one, the Raji itself is not court-approved. As you all know, it's the court-approved rule is Rule 411. The standard, the legal standard that we briefed for the court, we believe is that the instruction is only inappropriate and error subject to reversal if, number one, it is, truly, there's true evidence that it was harmful in this particular case. And the second is, it has to directly or completely misstate the actual law. The instructions that were given here, and there were two limiting instructions, one at the time the testimony was given and one in final, and they directly followed Rule 411. They didn't follow the Raji because, as the court pointed out, that would not be an accurate statement to this jury because I've already let this information in. We've already expressed to them that that sort of information can be relevant for limited purposes, not for wrongfulness, not for liability. It can be, however, relevant for limited purposes. And the judge put in her final instruction, she gave that example about Mr. Nickel and the rebuttal there.
Your time is up, counsel, so
Thank you, Judge.
thank you. Ms. Vopel?
Thank you. I just want to make a few points. First of all, this case is about a member of an HOA. The proof showed, and it certainly did not show by clear and convincing evidence, that the statements that were alleged as defamatory were false or that she made them with knowledge of their falsity. They related to the unilateral decisions by board members Nickel, Capaldi, and even Tarter that were ratified after the fact in closed executive sessions, according to Mo Stein and according to the evidence that went in. Those violated the CC&Rs and the open meeting laws. The acts also demonstrated a lack of transparency, which Ms. Bendt was also very critical of.
What is our standard view on truth and falsity? Because the jury was instructed they had to find these statements were false, and do we second-guess that decision as well?
Yes, Your Honor, because the evidence is in the record that demonstrates that
But we don't have to defer to the jury to the extent there was conflicting evidence on the falsity of the statements?
No, Your Honor, you do not, because you have a constitutional duty. This involves a woman who is reporting about her HOA board in a newsletter. This court has a heightened duty. This is political speech at its clearest. And when a woman who is a member of an HOA is exercising that in a way that points to specific acts and is relying on the actual CC&Rs and the language of the open meeting law violation that this court can independently review to show that, yes, in fact, they were engaged in these unilateral acts, ratifying them after the fact in executive meetings, you better believe the court should not defer to the jury on that, respectfully, Judge. And here, every single statement that is alleged as defamatory is demonstrably true or substantially true. This is political speech,
Your time is up.
and to the extent that it's not $1.5 million worth of defamation.
Thank you. We will take this matter under advisement and issue a written decision in due course.
Thank you.
Thank you.